Ye- Hello. Yes, it is audible. Sure, 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 sure. Thank you for the kind invitation. I would like to share my screen. Uh, okay, the entire screen. Okay, there's one more problem. They are saying this session is being recorded, so there's no permission to use it. Okay, let me just disconnect and connect again. Then probably that recording function will be enabled. Okay, thank you. Hello. Yeah, I'm trying it again. Now, done. Yeah. Okay. Sure. Yes. Thank you. Yeah. Good afternoon, everyone. It is my pleasure to be a part of this August gathering in this international seminar on space law and global governance, outer space global governance by Modern Law College Pune. Uh, and I think it is a great initiative that has been taken by Modern Law College, which is not something that is taken, I would say, very often in the Indian context. But it's good that this initiative has been taken. And thank you for considering me to be one of the speakers for this seminar. And unfortunately, apologies, I could not join all of you physically. I would try the next time. I will make sure that the next time that I'm there. So today, after this great lineup of speakers who have already shared a brief background and an introduction about what space law is, the nature in general, and also a good overview both I could hear Divya Tyagi sir and Aditya speak on those issues, and it was really nice. I'll now like to go on a very niche area of space law, which is something that is gaining prominence with every passing day. And there are a lot of news that are revolving around Starlink, OneWeb, and they are also now starting to offer connections in India. So they are getting a good grand entry in the Indian market. Now, that again makes it very important that we talk about this issue. That is something that is at facing us, and we need to find a good, amicable regulatory mechanism to regulate its use and also balance the interests. So, moving ahead, uh, I would like to start with a few statistics about what I was talking about. As of now, a total of somewhere around 5,000 satellites in orbit, out of which around 2,000 are active. That is a figure like which is again, there are different figures, but somewhere roughly it is the figure. But now what is projected is that in the next uh, by the end of this decade, in the next 6 years, that this number of 5,000 is going to increase to more than 75,000. So that's the type of increase in the number of satellites that we are talking about. We'll see that outer space will be uh, becoming very populated, and that would be 6 times of the total number of satellites that have been put into orbit in the last 60 years. So in the next 6 years, probably it would be somewhere around 6 times of what was done in the last 60 years. So that is the huge number that we are staring at. That also will effectively mean that there's one satellite for every Earth surface square kilometer of 100 kilometers each side. So it would be something that would be covering a lot of our skies in the coming areas. Now that is again a different thing whether we would be able to see it or not, but it would be covering our skies in a very big manner. Now, the major players. So again, I think I should also speak about what's the nature of these satellites. Why there's an increase, sudden boom in the number of satellites. So there's a service. Mostly, it is internet service. We may also call it multimedia service, which now we are using through our terrestrial towers. Now, there's this concept which has been demonstrated and has also come out with remarkable results. So there are a few companies which are wanting to provide that facility of providing internet through satellites, eliminating the need of terrestrial towers. Yeah, we can just have one receiver and we'll connect directly with the satellite, and that would probably offer at least the same efficiency, or in fact it has also offered and it is offering better uh, capacity as well on the satellite to mobile or like PC internet. Now the most uh, important player in this is Starlink, which has launched 12,000 satellites, but it has applied for 32,000 satellites that it wants to launch in a phased manner. Now, there's again a very specific characteristic about these satellites which provide such kind of a service. They are mostly in the low Earth orbit. They are the very close to the Earth's atmosphere, and those are the closest we can say in terms of their distance from Earth. Now, that is something that is really important for us to get entry into space and go to higher orbits. We all have to pass through the low Earth orbit whenever there's a launch that's taking place. So Starlink is planning to put somewhere around 32,000 satellites in that area. And there's again a Chinese constellation. It has some 13,000. That is what it is anticipating. Then there's Amazon and OneWeb. All of them total of somewhere around 5,000 satellites. There's also an Indian startup which is trying to venture into this domain, but they are coming with a less number of satellites as of now. It is basically a technology demonstration that they want to do and then expand it further. So in the pie chart to my right, so I have tried to show as to how the demography of outer space will change. See, as of now, like if we take a very uh, lenient projection that no, the satellites won't be somewhere around 75,000, say around 60,000, that would be the number by the end of this decade, then that would be somewhere around, that would constitute somewhere around 87.2% of the total number of satellites. So that would be, which would be put in 6 years, that would be 87% of the total satellites in outer space. So moving on, again, this is again an AI generated image, but here what has been tried to depict is that maybe in a night sky, we would be seeing something similar to this. We would be thinking those are stars, but those are not stars; those are satellites. So that may be a possibility, maybe not in the real time future, but somewhere down the line that may be the possibility. So this is what it may look like. Now we all have to think whether uh, we want to see it. If we want to see it, should there be rules and regulations for that? And then again, the related effects also for such satellites. Now, I have tried to distribute the legal issues in five baskets. The most important one is related to space traffic management because with the increasing number of satellites, it would get crowded and there has to be really strict rules so that like there's no mishap in outer space. The next topic that I would be dealing with accountability and liability issues. Then I'll be moving on to environmental concerns. Then what is the hindrance that it may cause to astronomy, and how what is the regulation in terms of spectrum band of communication. So I would again be dealing with that part. So starting with space traffic management, uh, there are these four issues that need to be looked into. So, starting with the first one, Aubrey debris mitigation. Now, what is the debris problem? I also heard Aditya really well explained the Kessler's effect, how it may start a chain reaction. So that is again a very important phenomenon that we all need to keep in mind when we are discussing about regulation of space. So as of now, there are somewhere around 19,000 cataloged orbits that are larger than 10 centimeter. Like it would be somewhere more than or around the size of the ruler that we use in our pencil boxes. So some objects which are like not which are non-functional, somewhere around 19,000 of them are bigger than that, maybe in the lower 25,000 satellites by the end of this decade. Somewhere around 5 lakhs to 7 lakhs of smaller uncatalogued fragments, which we have not made a catalog, which we have not included it. So that may be somewhere around 5 lakh to 7 lakh. And that is also something that is very dangerous because we have to keep in mind that in space, an object is probably moving with a speed of hundreds of meters per second. So with a very high velocity, and if they collide with some other object with such a high velocity, even if they are smaller fragments, they have the potential to cause a great damage. So we are roughly seeing that there may be somewhere around 7 lakh potential threats out there in outer space, and which any small touch with any satellite, it can start a chain reaction, the Kessler's effect syndrome, and it may also cause the satellite to be rendered useless, on which that collision will happen, may happen. So increase in now, since we are seeing that there's a increase in the number of satellites, so that is also leading to many close approaches between existing satellites. Uh, like say there are two satellites that are moving, and they are moving at say 100 kilometers apart, but they need to put the satellite in another orbit. That brings it closer to the other satellite by say 50-meter distance. Now, even if there's slight maneuvering from the designated course, if it is due to some unforeseen situation, then there's a possibility that both those satellites can collide. So those are called close approaches, but again, close approaches uh, as of now, like it is the highest that we see would be the probability of collision would be somewhere in 1 in 100. So that would be a very remote collision possibility, 1 in 100. But again, that is decreasing. Previously it was the probability, uh, that was the average probability was somewhere in 1 in 1000 would be the probability. Now it has come down to say 1 in 100. It may further come down. So that is again an increasing phenomenon that we are observing. Then we also see that there is a lot of uh, effort that is required to monitor the satellite's movement, and not all satellite operators want to get into that domain, put in their resources there, put in their capital, and they may want to put their business side, allocate more resources to the business side than this. So that is also something that is again uh, not a good sign when it comes about safety of space. And we also need to keep in mind that historically, 15% is the loss that we suffer when we are launching. 15% of all the launch vehicles, along with the satellites, don't reach to the desired orbit. So that's the loss that we are suffering. So that again, a good chunk of that also goes and adds on to the debris population and becomes a debris. So that is also something that is going to add on to debris. Now, we talked about the risk, but how do we manage this risk? So there's debris mitigation and debris remediation. These both are very important subparts of debris management. So, like one is mitigation, where we are saying that no, now will not generate new debris. The other is remediation, where we are trying to manage the debris which are already existing there. How do we minimize the impacts? How do we minimize the damage that may be caused? So these are two aspects where there is work that is ongoing, and there have been some really good technological advancements in both these areas, and there are a few startups which are developing very very exciting technologies. Like one startup has made a net. So whenever it wants to take a satellite which is a debris out of its orbit, they'll with their net they'll go near the debris, and it will get stuck in their net, and then they will again roll it back inside them. So that is also an idea, and there are other uh, interesting concepts, and the testing is also in different phases. So these are the things that may be done. But should we have mandatory regulatory requirements for deployment, operation, and end of life disposal of satellites? Should that be there? So here again, we'll have to appreciate that there are a few nations which are very active uh, in this front, and they have taken really good proactive uh, steps, and they have also been the guiding light for other jurisdictions to also follow suit, to act as an inspiration for other uh, states to also form their own rules for that. So I have given an example here. I want to give an example of FCC. So that is the regulatory body which regulates the uh, satellites, the like this aspect of giving licenses to satellites, coordinating spectrum and all. So there are several aspects. So these two aspects are dealt by FCC in USA. So they have come up with a guideline. They say that if your satellite is larger than this size, then you should have a maneuverability equipment that should be fitted into your satellite. So basically, what it will do is whenever a satellite is up there in orbit, now it sees that there's a collision possibility that may come up. So using that thruster or maneuvering device, they can move the satellite into different directions and avoid that collision possibility. So there now, as of now, most satellites I can say that are not having maneuverability capabilities, so they are probably saving that weight or that space to use it for putting in a radio transmitter or something which will bring in more smoothness in the operation of the satellite than the maneuvering capability. So FCC has come up with a few categories of satellites where it says that no, you'll have to mandatorily put it because you are carrying that capacity, you have that size wherein you can fit in this as well. So that is one thing that has been done by FCC. Along with that, there are also a few guidelines that are being discussed. But as of now, I don't think they are mandatory in any jurisdiction. Where they say that no, after 25 years, you have to put your satellite. You'll have to pull your satellite down, or like you'll have to sort of what to say is park it in a graveyard orbit or like get the satellite disposed. Yes, so yeah, that would be a good term. There are some thoughts that are discussing that there should be mandatory disposal norms for satellite operators who are operating the satellites. Like, say, once your satellite completes 15 years of age, now even if you are capable, you should dispose yourself because you may run a redundant technology uh, which can be easily exploited. It is vulnerable, or there may be other technological redundancies which may be exploited. So that is one of the reasons. But like to just phase out older satellites, there are some mandatory norms that are being discussed, and then there are also some norms that are coming in as to how a satellite should be deployed in orbit. What should be its process when it is separating from the rocket and then it has to move on its own for some time, or it can be uh, raised in a different orbit from the orbit that it is launched. Now when that operation is happening, how should that be done? What should be the procedure of doing it? What would be the SOP for that? Should there be regulatory requirements for that as well? And then operation of satellites. When there is a satellite that is being tasked, given commands, and then data is downloaded from there, uh, at that time, what should be the requirement of the people handling the satellite? And what should be the security architecture which would be covering that whole operation? Blanket being a blanket sort of protection. So, what should be the regulatory requirements for that? There's also discussion ongoing on such issues. So that is one thing that can be done for debris mitigation. For remediation, again, there are active debris removal measures like what we are discussing, the startup which is coming up with a net sort of a thing. Then the third step that can be taken for effective uh, regulation is having a mechanism for active traffic management. Uh, like roads or like in seas, there are no formal rules for moving from one place to other. That's like for the air when there are no paths that are made out, or in the sea we don't have a path that is made out that a ship has to sail through this. Same is the case for outer space. Now, in such a scenario where uh, it is all left in the open and different satellites are moving in different directions in different speeds, so how should that activity be conducted? What should be the rules for that? So there are two aspects to that as well. The first aspect is that there should be capabilities which would be able to detect a satellite's movement and predict its future course. So that has to be really accurate. That is one thing, which we call space situational awareness (SSA). The other aspect to that is who would take the command to move its satellite? What should be the rules for that? If both are approaching each other, who will take the first step to move out of course? How should that be done? How should course correction be done? These are something that needs to be formulated. The other thing, yeah, so I already discussed that high quality position data should be there. And then the third thing that is again giving may be a very uh, potential high risk. So there are two aspects to that. Now there is such an aspect of physics involved, and our technology is so advanced that there are softwares which will come up with alerts that they'll do the calculation, they will map out the future trajectory of their satellite and the other satellites nearby, and then they'll make the assessment and give us the probability. That is one. The other is use of artificial intelligence and machine learning. It is getting more and more refined. But the question that arises that what if it is faulty in nature? What if it is uh, like not made to the effect that it should be made? If why, what if it is giving a wrong result? Are the regulations to check that first before like this those are implemented? Because the damage that we are causing, that we are talking here is huge. One satellite gone wrong, an entire orbital spectrum remains unusable for centuries altogether because it will be so filled up with debris. So, should there be a regulation to that? The use of softwares and technology for uh, regulating such movements. Norms of first action, yes, we discussed that, which satellite should will make the first move. And then again, this is a point that I want to make here. I was reading through that what is the boundary of air and space. So that is Karman line, which is the most accepted demarcation, which says that it is 100 kilometers from the Earth's surface. So they say after 100 it is space, and till 100 kilometer that's air. But that is again something which is not concrete, so that may also differ. And there is a, a sort of a higher altitude navigation that's happening in the stratosphere. We are putting in those hot air balloons, which are also having imaging equipments, and they can image Earth. Uh, they can observe the weather there, and they can also perform certain defense functions. So such areas then get very close to the satellites because satellites are also now operating in a lower Earth orbit. The population is higher there. So should we treat the 350 to 500 kilometer range to be a human flight zone? No satellite should orbit there because planes or other uh, air planes and other sort of equipments may be found there. So, should we also come up with this idea to prepare a special zone where human travel flights will operate? Moving on, so I'll deal with this towards the end. I'll come back to the other issues that I want to deal with. Now we have covered space traffic management. Moving on, talking about the accountability, liability, and insurance issues. So here there are two aspects that are laid out in the Outer Space Treaty. Outer Space Treaty says that every state has an accountability, a responsibility of responsible behavior in space. and to follow the norms laid out in the Outer Space Treaty. But it also contains provisions which talk specifically about liability. So there's a differentiation that has been uh, very well dealt with in the Outer Space Treaty. They deal accountability separately and liability separately. So if we see Article 6 of the Outer Space Treaty, it says that every state will be responsible for all the space objects that have been launched from their territory or from the launch enablers territory. They would be liable, they would be accountable for all their actions. So this is sort of a positive right, I would say, that is being given there, that you have to carry out all your activities in line with the laid out norms. So that is your responsibility. That also applies for the private players for whom you are the launching state. Now, launching state, the definition of that itself is an entire descriptive topic in itself. So, without getting into that, accountability, Article 6 tries to affix accountability for any loss, damage, or responsible behavior in outer space. It lays out the accountability part. Article 7 then moves on and then it talks about the liability. It says that whatever loss has been caused by space asset, whether private or public, of the launching state, whatever damage it has caused while it is in space or in the air or even on Earth, if it causes any damage, that state will be liable to the for reparation to the other state. That is what is laid out in Article 7. It talks about the liability, that you have the liability to make it right, to adequately compensate. So that again is not dealt in detail in the Outer Space Treaty, that how compensation can be worked out, what can be the remedial measures. When we move on to the liability convention, it contains the provisions for affixing liability for any wrong that happens in space. So then they talk about claim commission, which needs to be formed if such a claim is raised by one state and it is not resolved diplomatically. Then it talks about establishment of a claims commission where representatives of both states would be there, and then a decision would be reached, and that would be then implemented. So there are provisions like that. Uh, so liability convention also lays out that the launching state will be liable for its actions. Now here comes the issue: how are we going to affix the liability? Like, say a satellite has gone and collided with another satellite, but not due to its own fault. There's some other spacecraft or satellite which had collided with itself, and it went out of control, and then it went and collided with a separate space object, the owner of which is claiming damages from B. Now B says that it's not my fault, it's A's fault. You should claim from A. Now these are some issues which may come up in the near future. If such issues come up, what should be the mechanism through which we should be adjudicating such claims to decide that yes, whose liability should it be? How would we gather the evidences? It's not something on land that our officials would go and collect evidence and then produce it before the court. We are talking about outer space where we are dealing with framework is something that needs to be defined. In the Restraint Convention, Article 4 mandates that every state will register its space objects, and it will uh, make it adhere to the Outer Space Treaty. Now, there again, in the Registration Convention, it talks about registration. But what are the parameters at which we are registering the satellite? There are some parameters that are laid out. But at the time when that registration convention parameters were being made, that was when there were not such number of low Earth orbits, sorry, satellites in low Earth orbits. Those were mostly in the geostationary orbits, big size satellites, as so which we use for our DTH platforms. Those are big satellites. Those are in much higher orbit in the geostationary orbits. And the registration convention uh, guidelines for recording the details of the satellite are as per the needs at that time. But now the parameters have changed. We just now saw that somewhere around 90% of the total satellite population would be in the low Earth orbit. There are different parameters at what speed it would be moving. Is it having thrusters or not? That is something that's not there in the registry convention now. Whether they have maneuvering capabilities. So that should be detailed. And then there should be guidelines made that, okay, we'll not register your satellite if you don't have these things. If you have these things in your satellite, then only we would be letting you avail the benefits of outer space. We'll take the your responsibility, liability. Now again, the most important question that comes up with this background is what should be the limit of liability? A collided with B collided with C may go and collide with D. What if it's a big B line that is made out of it? Should A be held responsible for the entire chaos and mayhem that has been caused? How to decide that? Whether that would be something that A would be capable of compensating that huge damage. So, how do we create a very equitable sort of a regime where we not only take consideration of the damage that is caused, but also the nature of outer space in itself, how things happen there. What if people were careful, but in spite of that, for one small wrong, it created a chain reaction that exploded so big. So I didn't do that big a mistake. So how to balance it, equate it? That is also something that needs to be worked out. There can be one relief if there are insurance regulations that are put in. But for getting a space asset insured, that is also something where the premiums are really high. So there should be some mechanism which brings in some yardstick, some uniformity in the insurance regime, and that can be also utilized to a good extent to cover up the sovereign liabilities in case of a mishap. Because the primary liabilities on the state can in turn recover it or take punitive measures against the individual, but the primary responsibility is on the state. So how do we cover the state first? How should registration be allowed? How should uh, be the framework of operations of such satellites? All of that has to be really laid out in very detailed terms in order to handle the accountability and liability issues. There are also environmental concerns around operation of small satellite constellations. Since they are very close to the Earth's atmosphere, they have their method of disposal is that they will uh, put themselves in the path of going down to the Earth's surface. So then they will make a re-entry in the Earth's atmosphere, and then within a couple of minutes, without reaching the Earth's surface, they are completely burnt out. Nothing is left of them. So that is one mode of disposal that is very uh, widely followed in the low Earth orbit. That is also because of the reason that the satellites in low Earth orbit are really small. There are even satellites which are of 1 kg or 2 kg weights. So such small satellites, when they make the re-entry, they can easily burn down completely. Now, there are different kinds of fuel that are used for thrusters. So when that fuel is being used, that is a very hazardous chemical. That is one part of it. But along with that, there are solar panels, different kinds of uh, things that are used to make that satellite and operate it. Uh, that may also be really hazardous. As of now, like there are not many satellites. Uh, so then the amount of pollution that was caused d- uh, because of these events was really less. But now, if we are staring at 75,000 satellites in orbit, so they have to be really, yeah, I forgot to mention that. The smaller the satellite, the lower its lifespan. That is also something that is said. And it is also depends on the low Earth orbit. In the low Earth orbit, there's a lot of gravitational pull because it is closer to the so the object has to move at a very fast speed, high speed, so that like it can balance the gravity pull that is happening. So they also have a limited time span because once they are not able to live up to that standard, they will be pulled by the Earth's gravity to the Earth's atmosphere. So when a large number of satellites will be pulled and burnt in the atmosphere, that would cause some hazardous impact, maybe to the ozone layer, or like it can also be poisonous for people to inhale. Now, how should we regulate that? This damage, how to regulate that? What is the extent of damage that can be caused for this? What will be our permissible limit? So that is also something that needs to be resolved. Then space debris, we did discuss about that. That is again, these debris are also an environmental concern for space. So space environment. So that is also another aspect of space law, space environmental laws. So how do we ensure that it is maintained in its most sacred form? So that is also something that's a concern. Then we can have various sustainable practices. There are some non-mandatory uh, guidelines or like rules which have been framed by various industry associations. And there are also some suggestions by some academic institutions which are also being adopted by major players of the industry. So there's sort of a niche area building up around sustainable practices. And it is not due to any legislation or any agreement, but it is a proactive step that the industry is taking in itself while the laws are in the process of formation. So that is something that can be done to uh, ensure that there are less environmental concerns. Then there's also this impact that is making a lot of buzz, the hindrance that it is causing in astronomical activities. So I was part of a research group uh, based in Paris. So uh, they had the mandate by the International Institute of Space Law to come up with guidelines for regulating the harmful impacts that the satellite is causing on astronomy. And it also included the light pollution stuff that the satellite is also causing. So we did a detailed analysis, and then we came up with guidelines, which was finally presented in the United Nations Assembly, UNUSA, not the General Assembly. There in one of the sessions, it was presented. So in the United Nations is also actively considering this regulation of this impact. And the International Astronomical Union has also set up its own parallel working group, which is also coming up with recommendations. So that this is something that is garnering a lot of traction. Now, what is this that we are discussing here? Now, when a satellite is up there, it has to communicate with its ground station. The satellite needs to have solar panels, which will help it with having the power to do its activities. Now, both of these are needed. Now, these are the two things that also have a negative impact. Coming first to the solar panels. The solar panels, they reflect the light that they get from the sun on the Earth's surface in a particular orientation. Now, what happens is that our telescopes, which are situated in various secluded parts around the globe, they are trying to observe a very distant celestial body. Now, suddenly that satellite is making a pass by. Now, again, I'll also like to give this background. In the low Earth orbit, a satellite is orbiting the full Earth in somewhere around 6 hours. So, or 8 hours, even if you take it 8 hours. So, a satellite is completing the full orbit of Earth in 8 hours. So, in a day, that satellite is having three pass-bys over any place in Earth. They are moving three times over any place in Earth every day. Now, there's a telescope which is trying to observe a very distant celestial body. Now, what happens is that this satellite made a pass by. Its solar panel blinded the telescope and it got disoriented. The focus that was trying to be made has to be again done. That is one of the issues that is being caused by the small satellite constellations in the low Earth orbit. That is one. The second thing, is also a kind of telescope which we call radio telescopes, and in fact, those are considered to be more advanced because they are not using the visible wavelength of light, but they are using the radio wavelength of light, not light, the radio wavelength, and that they are communicating through that radio wavelength, and they are sending radio waves, and then they find out the characteristics of that body. So those are called radio telescopes. Now, these satellites are communicating with their ground stations in radio waves. Now, the telescope is also sending radio waves. So, due to that, what happens is that the signal gets blurred. The accuracy of the information that the telescope is trying to gather is not uh, being gathered. There is also an interference that is being caused. So it is probably getting confused the direction in which that wave had to go, since it matched with the radio wave emitting from the satellite. It moved in a different direction. It changed its course. So things like that happen. So due to this, what is the deprivation that is happening? All the developments that have happened in outer space, all of that started with astronomy. Without astronomy, mankind probably would not have been able to venture into outer space. So that was the foundation stone, and it can continue to be the foundation stone for much further developments, much further progress of mankind. But if it is hindered due to such activities, shouldn't we try to frame adequate regulations for its proper regulation? So that is something that is also a legal issue, and it is being debated in various forums, and probably it will be addressed soon as well. But yes, I also must mention that the small satellite industry is also taking really good proactive steps. Recently, the largest operator, Starlink, it came up with an announcement that it will add a black coating to its solar panel, so that it is like it is a it will add a non-reflective coating. Apologies, that is what they said, which will not reflect the light and will cause less hindrance to the telescopes. So there are steps like that that are being observed. Now, coming to the last part of the legal issues, it is about regulation of radio spectrum. Now, as I said, all satellites are communicating in a separate wavelength from with their ground stations. Now, imagine two satellites of the small satellite constellation. Since now there would be 75,000 satellites. If so, then there would be a possibility that there would be a crunch for the spectrum in which a satellite is communicating with its ground station. Because if two are operating from the same frequency, their message would may cross paths or it may be completely damaged. So, in such a situation, how should we come up with regulations to regulate that uplink and downlink? How should we adequately regulate that? That is also a question that is that needs to be resolved with this. That the mechanism for that this coordination is laid out by an international body called ITU, International Telecommunication Union. It's a very old organization, and it is tasked with distributing these wavelengths to uh, various countries. There's a mechanism for that, and these countries can then distribute it among their private or public players. There's also a mechanism for getting direct approvals without uh, going through the state for the low Earth orbit. But the point that I'm trying to make here is how do we make adequate changes in the regulation for ITU? Of course, there are changes being made for this, for regulating this spectrum use in the low Earth orbit, which was not the case earlier. As I said, ITU is an old organization, but it was mainly functioning to regulate the use by geostationary satellites because those were the norms those days. Now, how do we evolve from there for adequate regulation is again a challenge that needs to be crossed. So they have come up with this current guideline to regulate the launching of satellites in the low Earth orbit. They say that okay, if you say that you over the next 10 years you are going to launch 1,000 satellites. So, okay, but I'll not give you radio use permissions for 1,000 satellites because that would be depriving some other player. I need to see that you are really serious about that. So, what needs to be done? ITU says that when I give you frequency rights, within 2 years of that, you have to put 10% of the total projections that you have made before me. You have to put it in orbit. So, like 10% of 1,100 satellites need to be put within 2 years of getting the frequency right. So, then it will be extended again for the next 5 years, where 50% of the remaining satellites needs to be put in orbit, and then within the next 7 years, 100% of that should be deployed. Now it is again 2 years from 2 plus 3 is 5, not 2 plus 5 is 7. So it moves in that sequence. So within 7 years, the entire activity of putting 100 satellites has to be completed. So moving on to an instance, I have summed up what are the challenges and how that can be resolved with guidelines. But in order to stress the importance of this issue, I would bring to the attention of this August gathering an air crash that had happened in the US in 1956 over the Grand Canyon. And what happened is that there were two planes that were crossing each other, and they were not in control of the ATC. Sorry, not in contact with the ATC, and it was not the fault of the planes, but it was probably fault of the miscoordination that happened because there were no ATCs and there was no regulation for that they collided, and there many people lost their lives there, and it uh, attracted the attention to bring in air safety measures. So then after that, this uh, Federal Aviation Administration and National Transport Safety Board were established, and then they came up with standard SOPs, which formed the bedrock for aviation regulation of aviation. This aspect of communication that became the bedrock after this incident, and then that is what has inspired many countries like India to follow that procedure of giving clearance for takeoff, landing, and communication rules. So that has become really effective. But as Mark Twain has said, that history never repeats itself, but it does often rhyme. So maybe tomorrow an air crash may not happen because we have learned the lesson. But what if it rhymes into a satellite crash in space? So before that happens, it is an urgent need that we come up with regulations well in time in order to avert any untoward incidences. So, as I was discussing the Good Space Citizen initiatives that the industry is taking, so these are a few steps that proactively are being taken, and this is uh, a really effective solution to the problem, a really good, remarkable step. So they say that okay, any satellite will be first deployed in the lowest Earth orbit. Then you would be moving on your own slowly while taking into consideration the nearby satellite movement that is happening. That is in order to ensure that it is not going on in very high speeds, and along with that, that the space vehicle which will carry it up to the desired orbit or the allocated orbit, with the space vehicle that will carry it needs to come down. If it is not having the ability to come down, it will add on to the debris that is already there. So that's a very big reason why it has been decided that okay, the launch vehicle will take it to a certain low Earth orbit so that it can go down to the Earth's atmosphere and burn itself. But the other step that has also been taken is that the collision avoidance, how that can be automated, that there's no human error. The chance of human error is further decreased. But that again brings us to the uh, flip side of that, that how do we regulate and ensure that this automation is really effective and it is not flawed in itself. So there's again a mechanism that is being set up for high quality positioning data being shared among satellite operators so that like there is ease of coordination, that they know each other's location very well. Then another initiative is the dead man switch that is being put in satellites. So what happens is that when I have lived my life, I'm a satellite, I have lived my lifespan, then there's a switch that's there in the satellite, which once pressed, the satellite would be deactivated and it will move to the Earth's atmosphere. But if it is higher at a higher altitude, higher orbit, then it would be difficult for it to bring it down to the Earth's atmosphere. So there's something called a graveyard orbit, a designated orbit uh, in the geostationary orbit, where all the defunct satellites can be parked, and that is designated for that, so that there is no satellite movement in that orbit, and these defunct satellites can be parked. So the satellite uh, either needs to be put to the atmosphere or put in the graveyard orbit. So the dead man switch is also a really remarkable initiative that has been taken, and there is also a fixed schedule for deorbiting. As I said that uh, after 15 years of use or 20 years of use, the satellite will be mandatorily deorbited. A schedule is already fixed that will not be changed even if the satellite is in its good form. So these are a few steps that are being taken, and the UN General Assembly's first Committee on Disarmament and International Security in 2021 has adopted a resolution to reduce space threats and to encourage responsible behavior. So these are a few steps that are being taken in the right direction. With that, I think this I have already covered that what are the international law that is applicable, and what are the domestic laws that are applicable to in order to ascertain liability. How can that be done? So with that, I'll thank you all for being very patient with my presentation, and for giving me this opportunity to discuss this topic. So I would like to thank everyone for that. Thank you. Sure, sure. Sure. Yeah, that's a really good question, and that is something which is in a rapid phase of development currently in India. Recently, the government has come up with guidelines. Uh, it has come up with, I think, the telecom bill, where it is dealing with this issue. There are various uh, provisions which would cover this issue of satellite constellations. But along with that, a very positive step that has been taken in the last 2 3 years is the setting up of INSPACE, the Indian Space Regulatory Authority. So they are also coming up with various guidelines for all of for various space activities, and this is in the form of making currently, and we are hopeful that yes, the government will be taking really good steps in this direction very soon. My pleasure. Thank you. Sure. Thank you.
Yeah, yes. May I have the permission to present my PPT? Uh, yes. Can you please? Do I need to enter entire screen? But okay. Yes. Good afternoon, everyone. I'm Manisha Sagwekar, author for this research paper titled Legal Orbits India's Legislative Trajectory in Space Law, with my co author, Dr. Rohini Gote, Professor MES Garware College of Commerce, and I'm a PhD research scholar in Modern Law College. So, today I'll be presenting this paper on this with the title Legal Orbits India's Legal Legislative Trajectory in Space Law. So these research questions were come in front of while doing the research. So how has India's space legislation evolved over time, and what are the key legal challenges and opportunities in its trajectory towards regulating space activities effectively? Then how does India's legal framework is addressing the emerging issues in space activities such as space debris mitigation, planetary protection, resource utilization, and whether India's space regulatory framework is supporting the country's broader strategic objectives, such as governing private entities, technological advancements, economic growth, international prestige, IPR issues, and other things. So here, I would like to introduce the topic with India's space economy has valued at 6,700 crores, representing 2% of the global space economy. But now the projection is that up to 2022, 35,200 crores is going to be our next space economy projection. So that is going to count for 8% of global share. So this is the advancement where space programs are coming with so many activities, space activities. So striking a balance between the technological advancements and regulatory control. Now this is becoming the imperative to ensure the responsible use of space resources as well. Additionally, we'll have to address the space liability, the issues like liability, the insurance, that is going to be the crucial context of the space activities. So, what are the present framework for the what is the space legal framework for India right now? So here we are following our constitutional articles like Article 51C, Article 73(1), Article 253. We have the alignment with the international treaties, conventions, guidelines which are there, like our Outer Space Treaty and so on. Then we had this satellite communication policy of 1997, remote sensing data policy of 2001, and draft is there still pending, that is Space Activities Bill 2017. But the present space legislation, that is the only one thing we have, that is the policy, not as a legislation, but it is only a policy. So that policy, it is covering only role of private sectors, non-governmental entities. So we have lot many illegal issues and challenges. Due to the time constraint, I'll not be able to go into the details of these each and every heading. So these are the space liability compensation, resource utilization, space debris mitigation, security in space and defense, national security, dual use technologies, then space traffic management, environmental protection, sustainability, intellectual property rights, licensing and authorization, data protection, data privacy, satellite operations and their control, policy harmonization with the all other policies internationally which are governed by all the member states, then territorial jurisdiction, criminal jurisdiction, legal authority over private entities, overlap between the international treaties, so regulatory framework for emerging technologies, capacity building infrastructure, enforcement and governance. So now, which the policy which we have right now, even it has got the gap. No legislative authority as such given to INSPEC, that is Indian National Space Promotion and Authorization Center. It is just having a guidelines. It is not having the full control to control the legislative part. So no schedule is given for creating regulatory framework as such. No timeline is given for ISRO to have the transition out of its current responsibilities, and there is need to clear rules and regulations pertaining to FDI and licensing, government procurement to sustain the new space startups, liability in case of violations, and appellate framework for dispute settlements. So here I would like to conclude. The Space Policy 2023 is a just document with a vision, but still it is lacking. The early years of India's space program were characterized by reliance on international treaties, policy directives to regulate the space activities. The absence of specific legislation emphasized the dynamic nature of space governance, prompting the nation to embark on the path of formulating a dedicated legal framework to address the evolving challenges and opportunities in the realm of the space exploration. So here I would like to thank the organizers and for giving me this opportunity to present my paper. If may I have any questions, I would be very happy to answer those.
Yes, yes. Am I audible? Yes. Good afternoon, everyone, to all the dignitaries. My name is Ajinkya Barke. I am PhD scholar at Savitribai Phule Pune University Center at Modern Law College, Pune. So, my topic, yeah, my topic is synergies and intersection, exploring the nexus between space law, air law, and telecommunication law in global governance. So first, before understanding this, we must understand what is global governance. So governance basically means what,
So
to govern something, to look after and to govern something. So and when this particular governance is at a global level, it is called as global governance. When the all international level organizations comes together and they think about one particular topic, regarding governing our particular topic, that can be called as a global governance. Again, here political powers, again the international, all international countries, they are together, they come together and they make certain rules and formulate regulations. That is this particular rules and regulations may be called as governance regarding the global matters. Now we have to understand what is space law. Okay, so before understanding space law, we must understand the basic scientific definition of state, that what can a space be. Okay, so space basically means what? Vacuum area which is above the earth, which can be like told as 100 kilometers above the sea level. Above that is Karman line. So, and basically what are space laws? Now there are certain aspects which we see, which are in the space laws. So these aspects can be governed by a different level. When these particular aspects of the space are governed, these are called as space laws. Okay, so there are different bodies involved in it. For example, international bodies such as United Nations is involved to govern the laws regarding the space. So what all activities happen in the space? So for example, in air law, we may say that use of aeroplanes are there in the air. Again, the use of satellites are there. Again, now at today's level, we are sending our orbits on the orbits outside the earth. So all these things can be governed under this particular space laws. Okay, space laws address a variety of matters, such as example of preservation of the space. Again, this particular matters such as preservation of the space and the earth environment, liability for damages caused by the space object, the settlement of dispute, the rescue of astronaut. All these things also would be covered into the case space laws. Okay, so as my subject is synergies and intersection, so we'll just look at a relationship. So the relationship to the outer space, airspace, and the telecommunications are considered to be related areas. So this airspace and telecommunication are related areas, because the telecommunication, how does the telecommunication happens? We send our satellites in the orbit. So when we send our satellites in the orbit, naturally the airspace law also comes into the picture, and the telecommunication, the radio frequencies and the wavelengths. So that's why this particular there is a connection between this telecommunication law and the airspace laws. Okay, so again, we have discussed earlier that this regarding the airspace laws, the part of the air transport plays an important role. Okay, so we use like earlier we don't use the aviation, but later on when the technological development was there, we started using the aeroplanes. So for the first time in 1919, Paris Convention was incorporated regarding the airspace. After the Second World War, the important convention, which is also today applicable, that is Chicago Convention, was there in the 1994. So this Chicago Convention, it consists of 22 chapters. So it tells about certain rules and regulations, that how the air's territory above the particular land should be of that particular country. Again, regarding the high sea areas, all the rules and regulations regarding the governance in air are given in that particular governance in air. Again, telecommunications. Telecommunications, we all know that telecommunication takes place by the satellite. The satellites are there in the airspace. Again, the ITRs. ITR means International Telecommunication Regulations. There are certain international telecommunication regulations in this particular global governance, in which the global in which 89 countries are party to it. Again, the global governance regime for space as a crucial aspect for global governance. Why this particular space law become a crucial aspect for global governance? Because after the Soviet Union in 1957, he sent the Sputnik. Later on, there was Cold War was started between the developed countries to send their particular materials to particular satellites to the outside the space area. So that's why the United Nations formed this particular committee on the peaceful use of outer space, which was established in 1958. And again, the four international treaties which govern the human activities in the space, including the Space Treaty of Space Agreement of 1967, was there in this particular treaty. In 1957, again, this Committee on Peaceful Use of Space was there. This committee was formed because the space age began after the 1957. That Neil Armstrong was there. Who took hello? Yeah, 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 yeah. So again, Office for Outer Space Relief was given there. And lastly, I would like to conclude that there this particular laws, okay, air laws, they have specified certain air laws regarding in the Chicago Convention. The telecommunication are there with regard to IRs, and regarding to the space laws, the most of the things are based on the principles. So there is a particular need to make a certain laws. Okay, though this committee is there, ICO is there, UNOOCA is there, but there is a need that there should be a specific clause, because this particular global governance is of the outer space is based mostly on the principles. Okay, so I would be concluding my presentation regarding the Space law. Thank you, everyone. Thank you, Modern Law College, to give me an opportunity to present this paper. Thank you so much.
Yes, I am audible. Yes, you also audible. Okay, thank you. Yes. Can you see my share screen? Thank you, ma'am. Ladies and gentlemen, good afternoon. Myself, Ramakant Tare, PhD scholar of Modern Law College and Research Center. It's my honor to participate in such an important event on International Seminar of Space Law. Space law is a new branch of the international law initially elaborated under the auspices of the United Nations since 1960s. Space law is rooted in the triggered by the development of the space technologies and human space activities. Thus, it is the still young and bound to undergo constant evolution. Nowadays, the space technologies are advancing rapidly and space activities flourishing vigorously. Against this backdrop, serious consideration should be given to such a questions as where the space law is heading for, what the status of the space law holds in international law system, and what are the objective of and orientation of the space law. Today, I would like to take this opportunity to share with you my presentation and thoughts. In this speech, entitled Legal Policy Regime of Outer Space and Global Governance, I wish to address two questions. First, global oversight, and second, liability of state, outer space, and framework and case studies. So, I will start. Introduction. Outer space governance is crucial for peaceful and sustainable exploration. The legal framework must address property rights and environmental protection. International cooperation is essential for regulating space activities. The history of the Outer Space Treaty of 1967 laid the foundation for the space law. It prohibits nuclear weapons in space and established space as the province of all mankind. Subsequent treaties have addressed specific issues such as liability, registration of the space object. Current challenges of the outer space are the rapid growth of the commercial space acqui- uh, activities poses challenges for regulation. Space debris and cybersecurity are growing concern. The legal framework must adapt to address private involvement in the space exploration. The role of the UN in outer space are collaboration between the spacefaring nation is essential for effective governance. The United Nations plays a key role in facilitating dialogues and negotiation. Transparency, transparency and trust are the critical for the successful cooperation. Future prospect The future prospect of the space governance will be involved addressing resource exploitation and colonization. The legal framework must balance innovation and sustainability. Ethical consideration will be increasing important. Global oversight. The global oversight assessing the role and contribution of the international intergovernmental organization in the space governance are the space governance The space governance has become increasingly crucial as exploration and utilization outer space expand. International intergovernmental organization IGOs plays a pivotal role in shaping the overseeing activities. The IGO plays a critical role in space governance, shaping policies for fostering cooperation and addressing the challenges to the ensure the peaceful and sustainable exploration and utilization of the outer space. Despite facing numerous challenges, IGO remain essential actor in the global effort to govern space activities effectively. By enhancing collaboration, the strengthening regulatory framework, and promoting the responsible behavior, IGO can continue to advance the interest and humanity in the final frontier. I will mention one case study here. The Iridium and Cosmon Collision 2009. On February 10, 2009, two communication satellites, the active commercial Iridium 33 and derelict Russian military Cosmos 2251, accidentally collided at the speed of 11.7 kilometers per hour second and altitude of the 789 kilometer above the peninsula Siberia. The legal situation in that the international law applicable to the collision is mainly the, yes sir, last one minute, sir. In this case study, the liability convention dictates that for damage which occurs, the orbit fault must be determined. However, the legal definition does not currently exist for fault within the context of the liability convention. The liability convention has also never been formally invoked. All incidents to date that could have resulted in potential claim under the convention, including the Iridium Cosmos collision, have been settled by the respective countries outside the Convention 9. The conclusion of my presentations are effective governance of outer space require multilateral approach that balances the interest of stakeholder. The legal framework must evolve to address emerging technologies and changing geopolitical dynamics. International cooperation and dialogue are essential for shaping the future of space exploration. Thank you, ma'am.
Hello. Yes. Actually, I'm presenting from my sister's PC, so my name is different here. This is Uh, my vid. Am I okay? Hello. My video is turned on. Okay, let me check. Am I visible now? Hello. Okay. Sure. Uh, Thank you. Good afternoon, everyone. This is Advocate Nandini Shahasane from Pune. I'm practicing IPR and commercial law. I'm pursuing PhD under Pune University and second year student of Modern Law College, Pune. When I signed to this conference on legal and policy regime of outer space and global governance, I had a feeling of interacting with some extraterrestrial legal avenues which I had never explored before. But I thank to organizers to provide an opportunity of learning intricacies of space laws by way of conducting this event. My topic of paper my topic of paper deals with crucial subject of states legalities uh, in space laws. Name of the topic is legal liabilities of state in outer space, Indian perspective. So, objective of my paper is to understand the emerging challenges associated with the legalities of state liabilities in outer space, both on international and national level. Here I seek to dissect the legal framework governing these liabilities and explore their enforceability limitations, examining closely the international arena and the specific legal landscape of India. Under United Nations, there are five main treaties governing the space law. These treaties cover principles governing space exploration, rescue operations, liabilities for damages caused by the space objects, then registration of such objects. These treaties emphasize the peaceful and equitable use of outer space for the benefit of all humankind. So there are these treaties, uh, there are this outer space treaty, then there is a rescue agreement, liability convention is there, then the moon treaty is there, the registration convention. So these are the five treaties. So out of this, when we talk about states liabilities, two main treaties are important. The first is outer space treaty. So these are the principles governing the activities of state in the exploration and the use of outer space, including the moon and other celestial bodies. It mainly deals with responsibilities and liabilities towards space exploration and providing guidelines to use the outer space to keep international peace for benefits of all humankind and uh, use of the outer space without discrimination. Article 6 of the Outer Space Treaty, uh, it gives us the liability convention. So that provides for liabilities of state and settlement of the claims. It is the convention on international liability for damage caused by the space objects, and it talks about absolute liability of member states in case of their fault. So basically there are certain objects where it talks about the state's liability. So it first talks about the international cooperation and peaceful use in the field of space exploration. It talks about rights and obligations when a state or its agency is causing damage uh, because of their space objects. Then launching of object into outer space rules, So how to calculate the damages, what will be the damages, then compensation to the victims of such damages. So this convention talks about that. So even it defines what will be the damages. So it can be loss of life, personal injury, or other impairment of the health, or damage to the property of the state or person. May I conclude in 1 minute? Okay, so what I have highlighted in this paper, that when we talk about states liability, when we talk about these two convention, there is a basic main difference between these two convention is the first outer treaty is talks about responsibility only, so it does not mandate any such action, whereas in case of liability convention, it talks about the absolute liability, and so where it provides for damages. Considering the Indian perspective, why the paper is important and why this issue is important and what is the lacuna, the India does not have its own space bill uh, right now. There is a space activity bill of 2017, but considering so many space explorations India exploring into, there is a need for space activities bill. There is a need for law related to space activities. And what will happen if we will be having a domestic law in case for this domestic space law, we will be in a better position to ask for our rights. And when there will be when there will be any international issue where India will be party to that time we will be in a better position to lead our case and protect benefits of India and Indian agencies. Thank you. Can I leave?
Yes, sir. I'm audible? Okay. Yes, yes, sir. Good evening, all. Just I just remind. Good evening, all. My name is Patare John Kisan. I am from 2021, 22 batch, and my topic is space debris and analysis with reference to the space laws and debris mitigation guidelines. And this study highlights the debris mitigation guidelines, the impact of the debris mitigation guidelines to the space debris. Uh, Today, a lot of material are in the outer space, so it's very difficult to travel the outer space for the developed and developing countries. So, space debris is become a big problem for travel to space. So there is actually there is no any specific provision for space debris in any treaties or any international law, but the only the provision we can see in that is the guidelines in UN Committee on the Peaceful Uses of the Outer Space, that is COPUS. So these studies just highlight the legal framework of that international space law and the debris mitigation guidelines. Uh, Now just see the meaning of the space debris. The term space debris is actually not defined anywhere in the treaties or international law, but the Corpus has defined it all man-made objects, including fragments and elements thereof in Earth orbit or re-entering the atmosphere that are non-functional. So this is the definition actually given by the Corpus. uh, Now see the historical background. The first satellite, that is Sputnik, was launched on the in the year 1957, and then after 25 days, it it got non-functional. So that from that Sputnik, the space debris was produced. Uh, Actually, thousands of satellites have been launched after that, and many of these satellites have lived their useful life and stopped functioning. So some of them have developed problems before their end of life. All these non-functional satellites are floating in orbit without any control. If they collide with any other useful satellites in the orbit, they will turn unfortunate satellite also into a space debris. And another issue that is with the ASAT, that is ASAT is a anti-satellite weapon, which is which is a missile to destroy an enemy's country's satellites in its orbit. And the NORAD is the organization of United States which keeps the tracks of that launches and the satellites after that Sputnik event. Now, there are five treaties which gives the which are for the space laws. The uh, Outer Space Treaty, that is the Magna Carta of these outer space laws. Then there is the Rescue Agreement, then the Liability Convention, then the Registration Convention, then there the Moon Agreement. Then if you see a specific provision for space debris, that there is no specific provision there is no, or there is no specific law, but Article 9 of the Outer Space Treaty has provided some solution. That is, as per this article, the studies and uses of outer space should be conducted as to avoid their harmful contamination. The word harmful contamination is used. So this is the provision we can see in Article 9 of the Outer Space Treaty. And the 2007 Copen's space debris mitigation guidelines are given. That is, limits debris release during the normal operations, minimize the potential for breakup during the operation phase, limit of probability of accidental collision in orbit, avoid intentional destruction, and minimize potential of the post-mission breakups, limit of the long-term presence of the spacecraft, limit the long-term interface of the spacecraft. All these guidelines actually very helpful to prevent the space debris. Now, if you see this table, then before 1997, the ratio of the space debris was much more. But after the implementation of that debris mitigation guideline, then there is a decrease of the space debris. You can see this USA. In USA, we can see that the ratio is very much decreased. In India also, the ratio is decreased. So these guidelines are actually are very impactful in the space debris issues. So my conclusion is that though the guidelines are very useful, but the other laws, that is other treaties or international law, need or require some improvement. The amendments it requires in that treaties, or that in that five laws, or specifically in the outer space treaty. So this is, thank you very much.
Yes, sir. Are you able to hear me? Okay, I'll just, may I start with the presentation? Just a second. I cannot share it actually. Mm, uh, Actually, I'm not getting that share option. It's not active. Shall I start without? All right. So my good afternoon, everyone. This is Dr. Pradnya Pavurkar from New Law College, Mahim, Mumbai. My topic today's topic is outer space sustainability, a challenge for the protection of the space environment. So, what is space sustainability is all about? Space sustainability is to maintain the safety of the outer space environment, and from where for the greater humanity, and to continue to use the outer space peacefully for the purpose of socio-economic benefits for a longer term. Now, what is are we protecting the space environment from? The space debris, the accumulation of various debris that has already occurred in the environment. So these space debris are of two types. One is man-made debris, and that is natural space debris, which is created in the space itself. And another is man-made debris. One is natural space debris, and another is man-made space debris. So, what is natural space debris is? It is nothing but caused due to asteroids, comets, meteors, uh, dwarf planets, the explorers, etc., etc. Whereas what is man-made debris is all about. Man-made debris is nothing but which has been caused due to various launching of satellites, orbits, and the collisions of these kind of satellites or orbits, which has resulted into various kind of pollutants into the space. So a space waste is created into the space. Various other examples which I can give is missing equipments, rocket stages, and weapons which have been used in order to launch it. When this direct collisions happen, the space debris is created, which keeps on moving into the space. Now, it is very important to remove this space debris from the environment, because it is very dangerous for the environment and the weather of our earth. um, so how it is dangerous, like if for example I'll give one example of it, like the nuclear batteries which are used in the satellites, if they are exploded, they emit radioactive materials, and these radioactive materials are emits serious pollution or causes serious contamination if they are returned to the earth. Now, what is space debris remediation? In order to remove this space debris, we have to utilize certain methodologies that is called as space debris remediation. So, what is the objective of this remediation? Is to remove existing pieces of orbital debris through various methods. So, there are two types of methods. One is active debris method, and another is passive debris method. So, what is active debris method is all about? Active debris method removes the bigger or larger debris from the space, whereas the passive removes the smaller debris from the space. Now it is very important to remove this, and we have already been utilizing different methods like tethering, tugging, beaming, electrostatic tractor, ion beaming, relocation, lasering, etc., etc., which we have been utilizing in order to remove the space debris and to clean up the space environment. Now, numerous guidelines have been put forth at an international level with regards to the space debris removal. regard to space debris remediation. Them in the legal provision, the legal in the legislation, in the form of legislation, in order to make it binding. Now we already have certain international agreements, but most importantly, these are non-binding. So we have CUPUS, that is United Nations Committee of Peaceful Uses of Outer Spaces. It has given certain guidelines which talks about remediation of space. Another which I can talk about, UK's Space Sustainability Plan. European countries have made their own code of conduct for space activities. And also, India has provided a provision and a project which talks about space remediation, that is SPADX, SPADX. Now, I'm moving to the next topic. That is, what are the challenges that we face in order to, that is my main topic. So, what are the challenges that we face? Yes, I'm on the verge of concluding. Yes. Can I do a conclusion? Can I conclude it? Yes. Okay. So I'll directly go to the concluding part. Firstly, apologies for the internet connection. So we have to grow the awareness of space debris remediation. The most important part of space remediation is debris remediation is that various international initiatives has been already taken, but it may lead to war, whereas which has been covered by various articles, and it has been already discussed that satellites and internet lobbies are included heavily into it. So the challenges are posed to space sustainability. In order to do this, we have to impose accountability on the state members by imposing a binding agreement rather than making it a non-binding agreement. And this awareness should be taken care of because it is an urgent issue in space field. And if we are not in a position to take care of it, otherwise it would not only affect the atmosphere or the environment, but it will also affect the human health, animal health, and the plant health as well. So on a greater scale, it will deteriorate the management of our earth. Thank you very much for giving me this opportunity and considering me. Thank you.
Yes, may I begin? Yeah, I very good afternoon to everyone present here. I know it's been a very long day. Just give me 5 minutes. I've got 5 minutes. Let me just quickly complete. Um, is my screen seen? Okay, okay. Um, yeah, that's what I am doing. Um, is, is it available? Okay. Is it seen? Okay, there are two options. One is entire screen or a Chrome tab.
Okay. Not happening. Should I just go ahead like that? Yeah. So a big thank you to the team, Modern Law College team. You're doing wonderful. The topic that was given to me is the liability of states in outer space. I would be briefing about the legal frameworks and case studies as well. So have anybody of you wondered, what happens in space have actually revolutionized our lives. But have you ever wondered about the legal implications and who would be responsible when accidents or damages occur in outer space? So this presentation is would answer to this question. Well, there are two legal frameworks that we are going to concentrate. Number one is the Outer Space Treaty of 1967 and the Convention of Liability for Damage Caused by Space Objects, which happened in 1972. Well, the importance of the topic is the space activities have expanded, and after the launch of Chandrayaan 3, I think everybody is talking about space and space laws. So this presentation will delve into the international legal framework that determines the liability of damages of states for damages caused by the space objects. Well, the objective of the presentation is it would give an overview of the legal framework surrounding the liability of states in outer space. The first legal framework that we are going to talk about is the Outer Space Treaty in 1962. Well, this treaty came into effect in October 1967. This treaty was signed by 103 countries and ratified by 3 countries that are mainly the UK, Russia, and the US. This treaty was enacted to govern and supervise all the actions and affairs of the member states of the treaty. The Outer Space Treaty, which is also known as the Treaty on Principles Governing the Space Activities in the Exploration and the Use of Outer Space, including the Moon and other celestial bodies, is a multilateral treaty that forms the basis of the international space law. On February 2022, 112 countries are parties to this treaty. It states that the parties to the Outer Space Treaty bear international responsibility for national activities in outer space, including the Moon and other celestial bodies. In other words, a ratifying state is bound to the principles of exploration and use of outer space for personal purposes, international cooperation, no national appropriation, and no weaponization. Furthermore, the state is bound to ensure that all such activities are duly authorized and carried out under its continuing supervision. Well, the Outer Space Treaty imposes liability for damage by making a launching state internationally liable. Let me emphasize on the word launching state. Liable for damage to another state party, its own natural or juridical person on Earth, air, and outer space, if its space objects or component causes damage. The second treaty that we'll talk about is the Liability Convention 1972. It came on force in September 1972, redefining the liability for space damage. Yes. One, I think Ramakant sir had already talked about one case law, which is collision of Iridium 33 and Cosmos 2022-51. Let me just quickly talk about one of the case studies, which is the only case study which was ever constituted under the Liability Convention, which is Cosmos 954 case. In this case, the Soviet military satellite with nuclear power sources on board fell on Canadian territory. Fragments of this satellite were disposed over a vast area of uninhabited territory within the Northwest Territories and the provinces of Alberta. Well, it took them 1 year to establish Article 10 Liability Convention. Canada presented its claim to the USSR for compensation of approximately $6 million. And the USSR agreed to pay the Canada about half of the sum originally requested, but it never explicitly recognized its liability under the liability convention. Big thank you to Anana ma'am for giving me this opportunity and making me do this. I'd like to thank everyone. Thank you so much.
Can I share my screen? Okay. Yes, sir. Yes. Is my screen is visible? Okay. Okay, sir. Okay, no worries. So very good evening to all the respected members over here. The topic which I have been chosen for this conference is the need for space law in India and critical appraisal of the Indian Space Policy 23. Why I have taken this topic as my research area is air and space law, and since last 4 to 5 years I have been writing on this topic, and I think it is still there is an urgent need for India to have an efficient law on the space law. This is the roadmap for this presentation. I'll just, in short, I'll just discuss the backdrop. Then straightway I'll go to the overview of the Indian space policy, because the lack of the time, I will not explain much about the historical evolution of the space and all. Then I will have some critical analysis of this policy and how this policy have been emphasized the need for having the domestic law, space law for India. That will be the area. In my paper, I have been done a detailed analysis of the necessity for having the law. In backdrop, as I told, I will not have, as I don't have much time, so I'll simply come to that. This paper have been exclusively dedicated to explore the legal challenges for the space industry in India, which India may face in near future due to the absence of law. India was the party for almost all the United Nations space treaties for outer space exploration, except the Moon Treaty, and it is the obligation to the India to implement the objectives of all these treaties at the domestic level. So with this obligation, India is still facing the implementation issues, or you can say the implementation crisis, as we have not come up with the, as we have not implemented one of the very prominent need of these treaties, that is having a law and addressing the issues like registration, regulation, control, or IPR issues, insurance issues, and ownership issues related to the space. Now, these are some treaties that, as I have been noted, that India was a party to these treaty. Due to the time constraints, I will not go to the in details of these treaties right now. So now the regulatory framework in India for governing the space domain. Till 1990s, late 1990s, ISRO was the only agency in India which is accountable for the planning, development, and execution of the space activities in India. ISRO, no doubt, it has been played a very important role in the satellite development and launch, space science research, Earth observation, and developing the communication technology in the India. ISRO has been also engaged in the international collaboration since its formation, and ISRO have been taken India at a very prominent position in the space development. Another very important agency in India which taken care of the development in the space domain is the Department of Space, which is the government, which is the department of government, and it is mainly responsible to offer a policy direction to the ISRO. So, Department of Space is basically responsible to frame the guidelines and strategies for the development of the space sectors and to coordinate with the other government departments, specifically for the for incorporating the space technologies for socio-economic development. And also, the DOS as well have been teamed up with the ISRO and help the ISRO, to achieve its objectives, objectives of India's space program. Now, recently in April 2023, India have been came up with the Indian Space Policy 2023. So ISRO have been issued this actually a long-awaited and much-needed policy, and this policy have been paved the entry of India in the new space age. Yes, we can say that, because when you go through the provisions of this policy, okay, it found that this policy have been basically framed only to introduce or incorporate the active participation of the non-government enterprises in the several activities related to the space. The vision of this policy is very noble. It says that to enable, encourage, and develop the flourishing commercial presence in space. That is the vision of this policy. The key highlights of this policies are, first thing is that it has been framed four distinct entities, okay, which will govern the entire space domain in India. So DOS and ISRO are already there. Along with them, InSpace will be there, and one New Space India Limited, NSIL, also will be there. Now, InSpace, that is Indian National Space Promotion and Authorization Center, will be basically responsible for new space launches, for sale and purchases of the satellites, and regarding incorporating the new technology in the space area. And basically it aimed for providing a level playing field for the non-government entities. Another agency entity that have been created under this policy is the New Space India Limited, NSIL. So it will be a government-owned company which will work under DOS actually, and this company will act as a mediator between the government and the industry. It will be like, provide the help and advice to the industry, so that the entry of the private industry will be hassle free in the space domain. This, as I noted, this policy have been actually had a red carpet for the private entities. So this policy have been provided a institutionalization of the active participation of the private enterprises in the space center. And so the ISRO will focus these, all these private entities will help the ISRO in focusing on research and development and advanced technologies. And also these NGOs will coordinate with the ISRO in designing and operating of the launch vehicles for space transportation and to establish its own infrastructure. Now, how this policy is significant for India? Okay, fine. I'll deal it directly. Okay, so critical analysis was the main gist of my paper, because I have been critically analyzed the paper. So the thing is that in 2 lines, I'll just tell about this policy. That this policy sounds very genuine and good. It has a noble vision, no doubt. But no policy can work effectively unless it is backed by an efficient law. So without law, this policy will be effectless. That I want to note here, because it needs to be supported by comprehensive rules and regulations. And for this purpose, now we have a need for a comprehensive domestic law. There are n number of reasons are there that why we need the law. Since many years, we are begging to the parliament. We are saying that a law should be there. Space Activities Bill 2017 was also there, which was pending before the parliament for a long time, but it has been never passed. So now we want a law, because we have already invited the private sector in the industry. We need to decide their liabilities. We need to foresee the future challenges legal challenges in the space industry, and we need a solution for it. And that solution is not possible without having a law. For that, we have to also revisit our Indian Constitution, specifically Article 51 and Article 73. When we are talking about incorporating the international policies and international law at the domestic level, we have to be more towards authorization and towards the supervision of the private entities who are coming to the space industry. Indian judiciary also is facing tremendous problems because of absence of the law while resolving the issues of the private industries in the space. Definitely. So, in the concluding remarks, I again say that India absolutely requires an independent, clear, and efficient domestic law on the space. It will be required because to boost a healthy relationship between private companies, which we have already welcomed, and ISRO, and space policy 23 is also required to have a clear and transparent provisions. Policy seems to be vague at some times because the demarcation of the roles and functions of all these four entities have not been done in the policy, in this policy. So thank you so much for giving me this time and giving me this opportunity. Thank you.
Hello, am I audible, sir? Yes, sir. Yes. Yes, sir. Yes, sir. Good evening, everyone, respected dignitaries, honorable teachers, and my dear friends. Today, my topic for the presentation is autonomous space objects and international space law, navigating the liability gap. Ever since Gagarin entered space and a little later Armstrong set foot on the moon, governments spent large amounts of money on space-related activities. The global space economy is gradually increasing. In 2018, the worth of the global space economy was estimated at $360 billion according to Space Foundation and approximately $415 billion according to the Satellite Industry Association. Now, in addition to being the increasing investments in the space industry also come from the private sector, the so-called new space. In addition to the new actors, new space also includes innovative industrial approaches, space-related technologies contributed to the growth of the private sector, and by developing innovative technologies will continue to do so in the near future, as indicated by Jet Propulsion Laboratory, a global leader in planetary exploration and space-based astronomy that supports the missions of National Aeronautics and Space Administration, the NASA. Regarding these new innovative technologies, developing autonomous systems is a top priority. Autonomous systems are equipped with artificial intelligence, that is AI capabilities, and function without human intervention. The introduction of autonomous systems in space activities does not come without legal implications, especially in what concerns issues of liability. As far as we know, there are no cases yet requiring the application of space law in the context of damages caused by an AI system. However, if we look at the evolution of AI systems in other industries, such as the autonomous ships, or for that sake, if we consider self-driving cars industry, many incidents already occurred. We believe we should anticipate future incidents involving autonomous space objects and consider a framework for liability regimes in order to avoid situations in which liability cannot be attributed, in other words, a liability gap. Now, therefore, my paper analysis whether existing legal frameworks are capable of dealing with liability for damages caused by space objects, and if they are capable of dealing with incidences caused by AI, specifically by autonomous space objects. Now, I'll directly go into the concept of artificial intelligence. In brief, I'll explain and then move forward with my topic. The AI systems aims to realize a goal by acting in the physical or digital dimension by perceiving the environment through data acquisition, interpreting the collected structured or unstructured data, reasoning on the knowledge or processing the information derived from this data, and deciding on the best actions to take to achieve the given goal. The European Commission states that AI refers to systems that display intelligent behavior by analyzing their environment and taking appropriate action to achieve specific goals with some degree of autonomy. Practical practical applications of artificial intelligence. Now, using AI for space-related activities enables space objects to gain autonomy. This offers a series of advantages, such as spacecraft being capable to rapidly assess and react to events and changing environments, thus increasing the reliability and productivity of missions. In the absence of AI capabilities, spacecraft cannot determine their own operational status and make decisions on their own. In space missions, who are dependent on the ground segment, many human experts are required, making such missions cumbersome and time-consuming. Sometimes it may take days before the data are processed, decisions are made, and uploaded commands reach the spacecraft. According to the European Space Agency, the AI description is emphasized by its convergence with other transformative technologies such as IoT, cloud computing, and blockchain, which are transforming entire industry verticals such as automotive, healthcare, transport, and banking. For example, the emergence of self-driving cars is made possible today due to the convergence and integration of technologies such as IoT, cloud computing, and AI. There is a growing necessity for processing the extensive amount of data generated by the new generation of satellites, such as the Copernicus program's data. Moreover, the success of future deep space missions, that is, example of traveling to Mars, will be dependent on various types of AI applications. Also, by enabling onboard decision making, AI technologies support spacecraft in detecting events using AI. Maybe even access to dynamic environments such as comets will become feasible. Space law liability regimes under the UN International Treaty. The space treaties form the core of the whole space legal system, concluded within the framework of the United Nations by the Committee on the Peaceful Uses of Outer Space. Out of these, the Outer Space Treaty and the Liability Convention provide the legal grounds for attributing liability in case of damage caused by space objects. Now, Article 7 of the Outer Space Treaty talks about, and it set forth the principle of international liability of the launching state for damages caused by its space object. However, several key issues remain unaddressed, such as what qualifies as damage, what type of liability regime is applicable, or what procedures should be followed in case damage occurs. Given these issues, the Liability Convention's purpose was to elaborate on Article 7 of the Outer Space Treaty and to establish liability regime. I'll not go into what is liability versus responsibility, Now, propose solutions for mitigating liability gaps. There are gaps wherein I've suggested some solutions for it. There are several solutions can be proposed for mitigating the challenges posed by the autonomous space objects to the liability regimes, even if they have not been tested in practice yet. The first is the international responsibility under the Outer Space Treaty. The Outer Space Treaty and the Liability Convention do not expressly provide that the Liability Convention should serve as the sole remedy for seeking compensation for damages caused by space objects. Thus, there is no reason why the more general concept of state responsibility could not be used as an alternative for obtaining compensation for damage in cases where the liability concept does not offer a solution. Yes. Yes, ma'am. To conclude, in recent years, the space industry has been revolutionized. Increasing budgets laid the grounds for technological advancements. Space objects launched by states and private actors are being increasingly sophisticated given their AI capabilities. The autonomy of space objects has become a priority for states as well as for private actors. Autonomous space objects are used, among others, to monitor the operation of satellites and climate change, are implemented in space stations operated as virtual assistants for astronauts, and they support exploration on planets where on-site conditions are still too dangerous for humans. Moreover, there is an increasing number of situations in which human control over a space object is no longer economically or practically feasible. Now, the introduction of AI systems in space-related activities does not come without legal implications, especially regarding liability matters. Autonomous space objects may display unforeseeable behavior by being capable of taking decisions on their own, thus challenging the existing liability frameworks under the Liability Convention. The optimal solution for mitigating such challenges would be the amendment of the Liability Convention for addressing the latest technological advancements. Initiating legal discussions related to the potential damages caused by autonomous space objects is required in order to avoid situations where liability cannot be attributed, that is, a liability gap. So, mapping the legal framework in advance is preferable to a post factum intervention, in which scenario an incident would have occurred already. That's all for today. Thank you, ma'am.
Hello, good evening, everyone. Myself, Advocate Ashish Patankar. The topic for today for my presentation is ensuring long-term viability of outer space activities, legal and its policy imperatives. So, to start with, the United Nations has discussed the idea of sustainable development on Earth in number of global summits over last 40 years. So, this is not something new. This is going on since last 40 years, and these summits have taken place across the world. And we have also been, as India, we have been part of it, and we have given a lot of contribution in these summits. So, we have played a vital role in these summits, and the idea of extending the concept of sustainability to the outer space is, this one is of much more recent development. This was since last 10 to 15 years the development of sustainability has taken place, and it is the result of realization that the environment of Earth's globe orbital space constitutes a limited resource that is being used by increasing number of space actors. So, like non-renewable resources, these are also limited activities. So, we need to utilize it properly. And these space actors include state, commercial actors, and other non-governmental entities as well. While doing so, concerns have been also raised regarding the safety of it and the space operations and long-term sustainability, that is LTS, of space activities as a result of 3 to 4 factors. And the most important 3 to 4 factors are space derbies, the increasing complexity of space operations, even the emergence of large constellations of satellites, and the increased number of collisions and interference with operations of satellites. So these are the main factors which have been dealt by United Nations. And by collaborating on global scale, it is required that to address these features, United Nations has played a vital role, and they have formed one committee known as United Nations Committee on Peaceful Uses of Outer Space. In short, it is called UN COPUS, and this is the most prominent international forum for discussing these issues, and they have played a vital role regarding it, and India has also played a vital role by giving them important suggestions. So in last 20 to 25 years, this is developing, and now we are at a stage wherein proper care has been taken. Thank you. Thank you.
invite our colleague, Assistant Professor Kshitij Badhavan, to join us on stage. I request the chairperson of today's paper presentation to kindly share their feedback and reflections on today's event.
Ladies and gentlemen, from the 10 participants who participated in presenting their papers, I find only 3 of them have got good delivery. See, the others, I don't mean to criticize, but they did not have the skills of public speaking, because some of them were using the word like, some of them were getting stuck in between. It was not flowing language. So the last 3 participants were very good in delivering the speech. I think 2 of them were advocates. Yeah. Last was an advocate, Ashish, and then a person the 6th person, Pragya Pavulkar. Pavulkar, actually, yes. Am I correct? Yeah, Pavulkar. Yeah. Her delivery was, apart from the delivery not being proper, but English also wasn't proper. For example, batteries are exploded. It would be in a past tense or past perfect tense. The data, as far as data is concerned, most of them had quite a lot of data. Some of them data and facts, and some had it was supplemented with statistics in some cases. By and large, most of the speakers had knowledge of the subject. Some of them elaborated on law points. That's very good. We have to bring in the field of law.